Those of you that were at the last session, thank you very much for returning and coming back, and for all the newcomers, welcome, and I'm glad you could make it. My name is Maureen Redeker. I'm an attorney at Gilliland and Hayes here in Manhattan, and tonight we're just going to talk a little bit about the other half of estate planning that we didn't get to last time, and that's wills, trusts, beneficiary designations, and related items, and related processes associated with all of those. Because I am an attorney, I have to give a little disclaimer that this is for educational purposes only, and your individual circumstances can make all the difference in the world when considering what is best for you. So we'll start, and pardon me, I'm going to have to kind of go back and forth with these slides a little bit. Estate planning is about you, your family, your stuff, and the state is really the easiest way to put it. And not to mention the unpredictable timing of events. Nobody typically plans to die anytime soon, but sometimes it happens. Nobody plans to become disabled or suffer a severe illness, but sometimes that happens. So this is about getting ready for those times while you are able to make decisions and are conscious and aware of who your heirs are and that sort of thing. Our sessions, we're really talking about who would have control of you and who would have control of your stuff. Last time we talked a little bit more about who has control of you in the context of healthcare powers of attorneys and living wills. And then who has control of your stuff is governed more by the general powers of attorney that we talked about last time, and then all of the things that we'll talk about today. And I will say, if you have any questions at all throughout this, do not hesitate to interrupt me. I thought it was really great last time. Everybody piped in with questions and comments, and I think that makes it better for everybody. So please feel free to speak up. So what are your options to transfer your stuff at your death? Well, you can do nothing. You can use joint ownership, transfer on death designations, also sometimes called payable on death designations, depending on the asset. You can use beneficiary designations, for example, like you would in life insurance. You can execute a will or execute a living trust. There are different types of each of these, but these are your basic options. And sometimes you will use, and often will use, a combination of more than one of these. There are drawbacks and benefits to each one. I'm showing you this graphic just as an example. We're going to come back to this graphic multiple times tonight. We're going to call the guy in yellow Bob, and we're going to call the lady in pink Linda. Bob and Linda are married. And Linda has a car, her jewelry, and a checkbook in her name. Bob has a car and a business, is what that stock certificate is going to represent for our purposes, and a 401k or retirement plan, and they jointly own the house. And we'll play with those based on what the asset is that, or the approach is that we're talking about, but I just want you to be familiar with that. So what happens if you do nothing, if you take the do nothing approach? Well, the Kansas legislature will decide what happens for you, because they have put into statutes who will get your stuff. For example, if you have a spouse, and he or she, or potentially your minor children, will have certain rights to property, and we'll get into some of those details later. Creditors are then typically the next to be paid, and those are the people that have demands against the estate, who make a claim within 6 months of death, 4 months of notice. I won't get into some of these details later. For example, the state statutes say if you're an individual and you have no spouse, no children, all of your stuff will go to your parents. If you're an individual with a spouse, with a spouse and no children, it's going to go to your spouse. But if you're an individual with a spouse and children, a lot of people are surprised to find out that only half goes to your spouse and the other half goes to your children. A lot of people assume that everything goes to your spouse if you do nothing, and that's not the case. A court will decide who's the guardian of your children and will not have the benefit of knowing what your wishes are. And under the Uniform Transfers to Minors Act, it's kind of the backup if you don't have a trust for your minor children set up. the court will name a custodian for the property that is to go to your child, and then that ends at age 18 or 21, depending on what categories they got those assets in. And I won't go into those details tonight. But when that custodianship ends at 18 or 21, those children get assets outright, no strings attached, the property is theirs. So if they're 18 and you left them, they still have $500,000 left, then that 18-year-old is going to get that $500,000 that they're entitled to. That scares some people, other people not. So that's what happens if you don't do anything.
Mm-hmm. What if you're no spouse, no children, no parents?
Then it's going to go to your brothers and sisters. Yeah. Yep. And it goes on out from there, and the statutes have kind of a long list, and eventually it says it goes to whoever your next of kin are, and if they can't find anybody, then eventually it cheats to the state. So the next form of estate planning that we'll talk about is transfer on death, which is referenced as TOD, or payable on death, which is POD. Transfers on death or payable on death is a document or designation that transfers the ownership of a particular asset upon your death. For example, on your home, say you're the sole owner of your home, and you know you want your home to go to your friend Sherry. And so you can do a deed that says, and the statute has the language in there that you include, but essentially it says, upon my death, this property goes to her. And then on presentation of a death certificate of you, that property automatically transfers. Now, part of the problem is if Sherry has creditors at that time, if Sherry's receiving Medicaid or any other means-tested government benefits, that sort of thing, that can end up disqualifying Sherry from those benefits. So these by themselves do not provide that protection for whoever the beneficiary is. Beneficiary designations operate much the same way. When you fill out the beneficiary designation forms for retirement plans, for life insurance, it's going to transfer automatically to whoever you list on those plans. They both transfer outside a will or trust. So if you have a transfer on death for your house going to Sherry, and then in your will you say, I want all my real property to go to Steve, Sherry's going to get that still. Sherry, if you have specifically designated that piece of property, then it trumps the will or trust that you've created. So that's very important to coordinate all of those. For example, on checking accounts or savings accounts, a lot of times people will fill out the forms at the bank without necessarily realizing what they're doing, and they'll fill out, you know, their children on there or whoever it is. But really, then they go do their will and they put a certain amount to somebody else, and because that checking account was a payable on death account, that doesn't go in to fulfill that bequest that you left in your will. So bottom line is you just need to really make sure you coordinate everything to make sure it's in line with what you've really intended. It does avoid probate. It transfers outside the probate process. So if you did transfer on death or payable on death for as many assets as you can, and it's only permissible on certain assets, but if you did that and all you had left was life insurance that you had a beneficiary designation on, then you could avoid probate that way. It's relatively cheap, straightforward to do. It's just sometimes difficult to really coordinate everything through just this. So here's the graphic again. We've killed off Bob this time, and Linda's left. And Bob had a transfer on death designation on his car to his son. He didn't have any sort of will or anything, so there was no designation for that business interest that he had. And then there's the 401k, and his beneficiary designation there was to his daughter. Their house was jointly owned, and that's just a designation that you put in the deed that you're joint tenants with right of survivorship. And so there, if it was jointly owned between Bob and Linda, then Linda gets the house. Well, if Bob didn't have a will or anything else, typically under the intestacy statutes that we talked about, Linda would get half and the kids would get half. But that doesn't happen with these beneficiary designation. His son gets the whole car. His daughter gets the whole retirement plan, so or account, I should say. Then they're going to have to go through probate to retitle and value that business interest. A lot of people don't like the idea of their businesses getting valued in probate courts where it's public records, where anybody's neighbor, where their son's girlfriend, or whoever else can have a look at that and see how much it's worth. There are other things that you can do for business interests, but for example purposes, that's what would happen here if all he had was transfer on death, beneficiary designations, that sort of thing. Does anybody have any questions about that? Mm-hmm. There's a tenancy in common, and then it doesn't necessarily go to the survivor. So the one I was talking about was a joint tenancy with right of survivorship. That means whoever lives the longest wins and gets it all. Tenancy in common is a little bit different in that each of their interests, so like if Bob died, his half interest would go, if he didn't have any sort of will, would go half to Linda and half to his children. So essentially, Linda would end up with 3/4, and his children would end up splitting 1/4, so they'd each have 1/8. Does that make sense? So most of the time, if you're a married couple, it's going to be joint tenants with right of survivorship unless you've done some estate planning that makes it something different for some particular reason. And you can be joint tenants with right of survivorship or be a tenant in common with other people. It's just dependent on how you designate it in the deed. So, and I'd have to go back and look at the right of survivorship, but with tenancy in common, I know that's possible.
I'm on my brother's savings account at a credit union. Yeah.
As a joint tenant?
Yeah.
Yeah, and so that would allow you access as a full owner while you're alive and then after he passes away. Whereas a payable on death on a bank account, you wouldn't have any rights until he passes away. So the next option we'll talk about is if you have a will, then what happens? And what is a will? A will is a document in which you express what you want to happen to your stuff when you pass away, your assets. You can nominate the executor to administer your estate. This is often the person who will work with the attorney, make sure your assets are distributed appropriately, doing a lot of the administrative work associated with settling all of your debts, expenses, and distribution of your assets. You can nominate who you want to be the guardian of your minor children, and the court will give preference to whoever you put down unless they feel like for some reason that is not in the best interest of the children. But typically they will follow your wishes. Whereas if you don't have a will, they don't know what your wishes are. It can be tailored and customized to include a variety of other provisions, including testamentary trusts. So just because you have a will doesn't mean you can't have trust provisions in it. You can. They only take effect when the will takes effect, though. And we'll talk about trust provisions, but a will only takes effect upon your death. So as where we'll talk about later with a living trust takes effect right when you sign it, that if you include trust provisions in your will, then it only takes effect upon your death. It is the most common estate plan. It does require probate to transfer the assets, and it requires notice to the creditors. So here this time, unfortunately, to the ladies in the room, we're going to kill off Linda this time. Linda did have a will, and that's all she had. So for these assets that are all hers, whatever she put in her will is going to control that. Now, a spouse has certain rights to the property unless they consent to you disinheriting them. So if Linda wasn't really happy with Bob, say they're separated or whatever the case may be, and she left everything to her children in her will, but Bob didn't consent to Linda doing that in her will. Well, Bob would still have certain rights to her assets, and we'll talk a little bit more detail about that in a later slide. But let's say Bob consented and Linda left everything to the children. Well, if she leaves it equally, then they'll each have, the two children will have a half interest in each of these assets. Half the jewelry, half the car, half the checking account. Now, that can be done in a variety of ways as long as they get equal values. You know, the son may say he wants the car, the daughter may want the jewelry, maybe it's worth the same amount, and then you can do it that way. But that's essentially what happens. This would have to go through the probate process to get the car retitled, and to get the checking account retitled, and then to transfer the personal property. And we'll talk about the probate process next. So when I say probate, what does that mean? It's a court process in which title to your assets are transferred. It can be a number of different processes, different steps, different procedures based on what your estate is made up of. Some of the processes that typical probate includes is appointing a personal representative, inventorying the assets, that's making a list of everything that you had when you died, and anything that the estate has gained since. Paying debts and claims and giving notice to Medicaid recovery, collecting rights to any income. You know, if the estate owns a rental house, then it would be the executor's responsibility to keep collecting that income and then report it to the court. Settling financial and property disputes, selling property, and distributing and transferring property to the heirs. So, and typically, it depends on the size of the estate, but sometimes the court will supervise all of these step by step, and sometimes they won't. And it's just a matter of how you apply to the court when you're submitting your petition for whatever kind of probate process you're going to use. Often an attorney is involved, and that's where a lot of the costs come into play. So it really depends on, and I think we might have touched on this a little bit last time, it depends really how involved and how organized and how really just their desire of the executor to move this process along. If the executor comes and brings letters and throws them on the attorney's desk and says, what do I need to do with this? And doesn't make any of the phone calls and doesn't do any of that stuff, well, the probate costs can go way up. It also just depends on the number of assets. If property has to be sold, how many creditors there are, all of that affects just how long this can take. The estimates of how long it can take are, 9 months, 2 years, it really just depends, but it can take a while before it's all settled. If you have property, say in Missouri, then you're gonna have, that is not, if there's not a transfer on death designation or some other process that takes it outside of probate, then you're going to have to open a probate in that state as well. And then as far as the timeline goes, a will should be filed with the appropriate court within 6 months of the date of death. This is important because if it's filed within 6 months of the date of death, then you preserve your right to probate that later. So say you have this will, and then you realize there really aren't any assets to probate. There's nothing left. Well, you don't necessarily have to go through the probate process if you don't have any assets to retitle, or if there's $100 or $200 left, that makes it not worth it. There's a lot of different scenarios, but if you preserve it with the court, then if something comes up later, for example, you learn of a life insurance policy that doesn't have any beneficiary designations on it, or there's a number of things that can come up later that people realize. You would be surprised how many assets people have that their families don't know about. It enables you to do that. You also have a responsibility, if you know of and have possession of a will, to give it to the court. And if you willfully don't do that, you can end up having to pay attorney's fees to anybody who's injured who has that filed later on. So, so just because you file it with the court doesn't necessarily mean you're entering into the probate process. There's some differences there, but it is important to be aware of that 6-month deadline.
Okay, so what's the appropriate court? Is that the county court?
It depends where you live. It's the county in which the decedent lived. Mm-hmm.
Do attorneys keep copies of wills indefinitely, like 20 years or something, so that I'm aware of an older couple who died,
Mm-hmm.
and they indicated they had a will, but after they died, the people close to them said they couldn't find one.
Which sometimes happens, which is communication is very important.
Could be delusional, too. I mean, they may have said what they were going to and never did, or I don't know the reasons. But if one couldn't be found and you could identify the attorney, is that helpful for
Well, only the original of a will can be probated. So if we have a copy, it doesn't really do much good. We do, I can't speak for what all attorneys do, but we try and keep electronic copies for 10 years. That is not necessarily a standard practice. At one time, most attorneys were holding the originals in their vaults or in a bank's vault or whatever the case is, but malpractice insurers aren't liking that anymore. So it's becoming less and less common. So it just kind of depends.
So anyone who has access to your safe deposit box would have access to your original will.
If you put it in there, yeah. Mm-hmm. Yeah, in the ideal scenario, yes. So the next option is creating a trust. As we talked about, a trust can be created inside of a will. That takes effect upon death, and that's called a testamentary trust. A trust governs who you want to manage your assets, and that person is called the trustee or that corporation. There are trust companies that do it, so there's several different types that you can name, but whoever that is, they are the trustee. How you want those assets managed, so how you want your stuff managed, and how you want your stuff distributed and at what times and under what conditions. Basically, you're saying, I trust John Smith as my trustee to manage and distribute my stuff when I can't. A trust takes effect right when you sign it. So if you signed a trust tonight, you could include provisions in there about what happens when you're disabled and can't deal with those affairs on your own. It would also govern what happens when you die. So you would typically have different provisions that govern those certain circumstances. And you can get as detailed or as boilerplate as you like in those. Trusts often include provisions to delay distribution of assets to children. For example, if you don't want your child to have that $500,000 when they turn 18, you can say they don't get everything outright until 30, 35, never. It's really up to you. If you do that, typically there will be provisions of what the trustee can distribute from that trust for. So if you want your child to receive money for education, then you can say, while the money is held in trust, then I want that income and principal from that trust to be spent on my child's education. Or I think my child's going to be an entrepreneur, and I want at age 20 him to be able to have access to money to start a business. But it's up to the trustee to distribute that. So whereas in the other circumstance, at 18, the child could do whatever they want with it, no strings attached. In this case, it's the trustee, often in the trustee's discretion, it depends how you draft it, that's making those decisions, but following what you've put forth in your trust. And that can be a variety of things. Sometimes there are certain standards used to keep the assets that are for the benefit of the children, but to keep them out of their estate or away from their creditors, that sort of thing. You can provide care for your pet. There are provisions that you can include under Kansas statutes that provide a trust for your pet, and a lot of people really like that option and think that that way they know their pet is taken care of. So some of the specific types of provisions often added to a trust are trust for minors, which we've already talked about. There's a spendthrift provision, and essentially that says that not your own creditors, but any of your beneficiaries' creditors, so in this case that we've been talking about, the children's creditors will not be able to get at those assets until they are entitled to them. So if you leave it in trust till they're 40, and that's when it gets distributed outright, then only at that point will the creditors have access to that amount, which is a great protection, I think, for a lot of kids. And you'd be surprised how often parents have concerns about that. It is actually pretty common. There's also a government benefits provision that acts much like the spendthrift. And essentially it says, if my child or whoever the beneficiary is receiving government benefits, Medicaid or something else, then these trust assets can be used as supplemental to that so as not to disqualify that person from receiving those governmental benefits. And then there's a power of appointment. Essentially what that does, let's go back to the age 40 example. If you decide you want your child to have access to the principal of the trust with no strings attached, but they may have certain circumstances going on in their life that they may not want to take it at that point. They're going through a divorce or whatever the case may be. Then you can say at age 40, they have a power of appointment over such a portion of the trust. And that way, at that time, they can elect whether they want to take that portion or leave it in the trust. It's up to them at that point. It often does become part of their estate at that point, and there's some different requirements and qualifications related to that. But go ahead.
You talked about trust for minor children.
Mm-hmm.
What about an adult child who is going to need supervision for his entire life?
That has like a disability or something? Sure, you can put trust provisions in for that, and there is what's called a special needs trust, and we're not going to get into the details of that tonight, but I mean, even if all your children are 20 and above when you pass away, if you say they don't get anything till they're 40 or never, then that can keep on continuing. So it doesn't necessarily have to be minor children. It's just minor children can't inherit, so that's the only way that they can really get access to the funds without a custodian being appointed by a court, that kind of thing. But there are certainly trust provisions that you can include for special needs like that. A trust can be revocable or irrevocable. Generally, trusts are revocable unless you're doing some sort of planning purposes for tax, Medicaid, things like that. For estate tax purposes, you have to give up all rights to everything and be willing to essentially part with it now for all intensive purposes. For Medicaid, there's a 5-year look-back period, so if you transfer to an irrevocable trust that qualifies for this Medicaid separation, and then you have 5 years before you actually need the Medicaid, then that would be a reason to use the irrevocable trust. One of the main benefits of a trust is it does not require the expensive probate. Now, it is more expensive typically up front to set it up because it is so much more involved. But if you fund everything correctly and you coordinate all those beneficiary designations, those transfer on death designations, and everything else that we've talked about up to now, then you could have a very large estate and not have to go through probate and not incur that expense. What happens instead is your trustee, instead of the executor, is the one that distributes everything or holds it as you say in the trust document. So this is, go ahead. The trustee does typically get a reasonable fee. Corporate trustees, they typically have a set fee that they say like 1% of the assets of the trust or something like that. Otherwise, it's just a reasonable fee. If it's somebody, not all trustees are going to take a fee, but it can be a decent amount of work. If you have 5 kids that they're having to juggle all this stuff for, they may be taking time off work to make sure that all happens. So they do usually receive a fee. So it's not that a trust is completely without cost on the back end. That would be a misstatement to say that. There are costs for a trust on the back end. You just don't have costs associated with probate. And we like to think that it should be less than what you would have to pay going through probate for the same size estate.
You have like a dual trustee, say if you're worried that the first one may be deceased or whatever, rolls over to another.
Sure. Yeah, we usually have a provision that says during life, if you create a trust now, during life, you and if you have a spouse, you and your spouse would be the joint trustees typically. And if one of you were to pass away, then the other would be the sole trustee. Now this can change based on the individual circumstances. But then it says if both of you are unable or unwilling to serve due to death, disability, or any other reason, then you would name a backup trustee. Some people say, well, I want my kids to be in that position. I want them to have control over it, but I really don't trust a single one of them. I have 3 kids, but I want them to all be a check and balance on each other. And you can do that too. You can make them act together. You can make them act together on certain decisions. Sometimes we'll draft in there where it says for the sale of property, to borrow funds over $5,000, and name specific things that you're particularly concerned about and leave all the other day-to-day decisions to a particular person.
Comment more than a question. If you go to more of a corporate
sometimes.
Yeah, I've seen the criticism answered by saying, well, fortunately, John Doe had the ability to move the trust if he was not satisfied with the trustee's behavior or commitment to managing the trust. But he didn't have access to manage the trust himself. He could move it to someone who he felt was doing a more ethical or beneficial job for the purpose of the trust. Comments?
Yeah, I have a couple comments on that. You know, it really depends on the individual circumstances. We have some clients that have 50, 60-year-old children that they just don't trust with funds. You know, everything that they've given them, they've spent, they still don't have anything, even though they've been given money time after time after time. And so by naming that corporate trustee, it takes it out of that child's hands. And by not allowing them to change the trustee, it again takes it out of that child's hand. And while that child may not think it's in their best interest, well, it was the father or the mother or both. Those are their assets that they can decide what they want to do with it. And if that's what they thought was best for that child, then there's often a reason for that. Now, a lot of times there is flexibility built into a trust. For example, there's what's called a trust protector that can be kind of a backup for a lot of reasons. And it's a third party other than somebody else that can request a change in trustee. So it's an independent person that maybe you trust. So there are things that you can do so that somebody doesn't get stuck. As far as the corporate trustee having adverse interests, I mean, they're required to follow what is in the trust documents and follow those rules. And they have very specific duties that are often incorporated into trust under what's called the Uniform Trust Code that they have to follow in how to diversify assets and all that sort of thing. I would say if that's happening with the trust company, you haven't picked the right trust company.
Well, and that's the problem. Mom and dad may not know that that isn't a very effective trust company. A lot of this has come about because of the economic downturns in the last decade. The banks just, it was put in this, and this. It's sort of it goes on its own, even though it may go down 30, 40%. We don't care because that's the way it's set up. We're not going to fool with it. We're just going to write it out. And that's not necessarily in the best interest of the beneficiary. And I'm not saying for John Doe to swing it over to his friend Bob so they can work something out. I'm saying from one fiduciary to a different fiduciary.
To another corporate trustee. Yeah. I mean, it just depends. Like sometimes we'll say if X trust company is unwilling or unable to serve, then it has to go to another trust company that manages over $10 million in assets or something to make sure that you get one that is sophisticated enough for whatever your original intent and purposes were. Anybody? Oh, we're already here. So this is the basic trust concept. Essentially, this is your trust is like a box, and you're just dumping everything into that box so that all the retitling and everything is happening while you're living during your life. If you notice, there's an IRA over there with a no sign, and that's because an IRA can't be owned by a trust. It has to be owned by the individual owner. So the way you coordinate that is with beneficiary designations. So that's just an example, but there are certain things that won't necessarily go in your trust right now, but you may do a transfer on death designation. Sometimes people with businesses don't want their shares in the business to be owned by the trust right now because they have business partners. They don't want everybody doing that, and it really just depends on the circumstances, but you could have a transfer on death designation for your shares at the time you pass away to go into your trust, and then there's a lot of different circumstances and provisions that you can put in for that. But this is just kind of the visual that gives of what a trust is in pictures.
Strictly IRAs or 401k?
Yeah, most retirement plans are subject to the same. Let's see. So now we have Bob and Linda again, and thankfully they're both still living. We didn't have to kill anybody off for this example. So essentially, kind of like the box, I've done 2 circles, and each circle represents each of their trusts. There is such thing as doing joint trusts for spouses. We don't often use those, but it really just depends on the attorney's preference. And and I won't go into all those details. But essentially, Linda's put her checkbook, her jewelry, and her car into a trust. And the way she's done that is she's redeeded her car or retitled her car with the Department of Revenue. Her jewelry, she signed what's called like an assignment of personal property. Sometimes it's called a bill of sale, essentially a document that you sign at the same time as your trust that says, I transfer all my personal property into the trust. Her checkbook, she puts on a document that she signs at the bank that the owner of the trust or the owner of the bank account is her trust. And you don't necessarily have to change your checks to show that it's your trust who's the owner. It can still have your name on it. But that way, when she becomes disabled or dies, her trustee has control of all that that's already in there. They don't have to retitle all of those after she passes away. And while she's disabled, they can have access to those as the trustee. The house, typically what you'll see when you have the typical spouse scenario is half will go into Linda's trust and half will go into Bob's trust. On Bob's side, he has the car and the business that will be dealt with through his trust. Sometimes with businesses, there's also what's called a buy-sell agreement, which is an agreement between shareholders or members, essentially the owners of the business, as to what happens when somebody dies and who the shares have to be sold back to. Does the company get them? Do the other shareholders get them? So that Bob's partners don't have to go into business with Linda, which is typically what would happen. The 401k I have in a different colored circle there because of what we talked about before, and that will be coordinated by beneficiary designations. Anybody have any questions about trusts, what they are, why you use them? Mm-hmm. It's up to the lawyer's discretion. The reason that we don't typically do them together is because people go through major life circumstances and changes all the time. And we think that the process is likely easier if you have your own trust. If your spouse passes away or if you get divorced or whatever the case may be, that then you still have rights to your own assets. Now, there are provisions that you can put in a joint trust that make that happen. We think it's just a little bit cleaner to do it like that. But there are a lot of attorneys that do joint trusts, so there's nothing wrong with it.
Just to make sure then too, so okay, you've got the trust, you are your own trustee.
Uh-huh.
It goes effective and you sign papers. You decide you did the new cars.
Mm-hmm.
So you just have the freedom to do that and then have to.
And then you just put it in your trust names. But sometimes, with cars, often with cars, people will leave them in their individual name so that a trust isn't showing up, attracting people who think that trusts are equated only with wealth. So they will just do a transfer on death designation to the trust. But if you went and bought a new house, then right from the beginning, you would title that in your trust, if that was in line with your estate plan. Or yep. Yeah. If you're your own trustee, if you, the grantor, are your own trustee, then essentially it says you can change the provisions of this trust at any time if it's revocable, that you can make distributions of assets, that you can withdraw assets, that you can put assets in. It's really very similar to acting as you would without the trust, but the legal titling part of it is what's different. Back a few slides ago, I talked about that you can't disinherit your spouse. And these are some of the details. I apologize, this is a lot of writing on here, but you can disinherit your child by will or trust, but you cannot disinherit your spouse without his or her consent. So if you, I don't know if you've ever seen a will that has a consent by the spouse behind it, with an affidavit behind it, then whatever it says in the trust, then that, or the trust or the will control. So some of the protections that Kansas statutes provide are one for the homestead. If you live outside incorporated city limits, then you can protect up to 160 acres and any improvements on those 160 acres. If you live within a city, then you can protect up to 1 acre and any improvements on that property. It has to be property that you're using as a primary residence and that the spouse and or minor children continue to live in after the death. So that's one protection. Kansas is one of the, I should say, I don't know if it's few, but not all states have this protection. We'll put it this way. Go ahead. So the creditors can't get to it. So if you go through the probate process and you give notice to the decedent, the person who died, their creditors, then they can't come take your house out from underneath you if you're using that as your primary residence. Does that make sense? There's also what's called a family allowance, and it provides specifically in the statute, and it's for spouse. Typically it will go to the spouse and minor children. If there isn't one but there is the other, then it will be for their benefit. First, there's personal property, 1 automobile, provisions for fuel, provisions and fuel on hand necessary for the support for 1 year. A reasonable allowance, not more than $50,000 in money or other personal real property at its appraised value. And then that property is also not liable for the payment of the decedent's debts, expenses, except the liens that exist on that property at that time. I should say too, the homestead, it's not exempt. I mean, if you don't pay your mortgage, then they can come foreclose on your house. So there are some creditors that can get to it, but if your husband had a lot of credit card debt, then they can't come and take your house typically. And then there's also what's called, in addition to these two, there's also called the spousal election, and this is why you can't really disinherit your spouse. The surviving spouse of a decedent, if that decedent was a resident of Kansas, then that surviving spouse can elect to take a certain percentage of the decedent's estate. And that percentage is determined by the length of the marriage. And I think, don't quote me on this, but I think it's once you get to 15 or 16 years, then you're entitled to half of it. And up until then, it's just kind of a graduated percentage that's set forth in the statutes. So if Bob didn't leave anything in his will to Linda, Linda would still have this right if she didn't consent to his will. And then the elective share percentage, interestingly, comes from probate assets and non-probate assets. So they can make claims against the beneficiaries from those transfer on death designations and that sort of thing to satisfy their spousal election. And then, again, the right to spousal election is in addition to the homestead and family allowances. Go ahead.
Because the spouse and children, does that include stepchildren?
That are not blood related or adopted? My guess would be no. I haven't looked at that specifically. So would it be the stepchildren of the decedent? I don't think they would have those same rights unless they were adopted by their stepdad. But I haven't looked into that specific issue, but based on what the statute says, I don't think they would have those rights. That's just what it says in the statute, but just generally your personal property. Yeah. Sometimes Kansas statutes are not the best drafted statutes I've ever seen. Yeah. So this slide just talks about the current estate tax exemption. So what we mean when we say exemption is your property up to your assets, your stuff up to this amount is not subject to estate tax. Once it hits the estate tax exemption amount, anything over that is then subject to estate tax. Right now, last year it was $5 million, and this year it's $5.12 million. I think it's about 0.3% of the population actually has to worry about this. So it is not very common right now. So if you had $10 million just generally speaking, you didn't do estate planning, you didn't do anything, then I guess what would be 4.88, something like that. I'm not a math major. 4.88 million would, 35% of that 4.88 would go to the government. There's a $13,000 annual gift exclusion. That means that you don't have to pay gift taxes on if you gift, and you can gift to as many people as you want with that $13,000 exclusion. If you and a spouse or you and a sister or whatever, you're each gifting to the same people, you each have your own exclusion as to that beneficiary that you're gifting to. As a couple, yes. Yes, without paying gift tax. Right now, and last year for the first time, there's what's called portability. Essentially, it allows spouses, if husband dies and he only had $3 million, so he had $2.12 million left in his exemption, then if the spouse files a document with the IRS, then she can later take advantage of that unused exclusion amount. Problem is, nobody really knows what's going to happen with that. So unless both spouses die in 2011 and 2012, we're not really sure how it's going to help you. Likely they won't retroactively take it away, but you never know. And also if you get remarried, that affects it. There's a lot of different things that can affect that. And then the long-term capital gains tax is 15%. And this is where it gets interesting. At the beginning of next year, if nothing happens, which sometimes happens in presidential election years, and it will depend on who's in office probably as to whether this gets changed. But right now, if you have $1 million and you die January 1st, 2013, let's say you have $2 million and you die January 1st, 2013, then $1 million of that is going to get taxed at a 55% rate. So $550,000 goes to Uncle Sam. A lot of people think, I'm not a millionaire, no way. Well, when you start including your life insurance policies and your real estate and any inheritance that you might receive, people start approaching that number a lot faster than what they think. So that's just something to be aware of. Don't automatically assume it's not going to apply to you. And then the long-term capital gains rate, tax rate is going up to 20%. Now, Congress could do something like at the end of 2010. They put these in place right in December at the end of the year. And the same thing can happen then. So really for estate planning, it's all kind of in limbo right now because nobody knows what's going to happen. And rather than giving us a long-term solution, they've chosen to give us a 2-year solution. And I mean, I guess they've given us something after that, but everybody thinks something will happen. I think I read that the last in Obama's proposal was that it would be 3.5 million exemption. But who knows if that'll actually be passed through Congress and ends up what's happening. And we have a little quote from Will Rogers that the difference between death and taxes is that death doesn't get worse every time Congress meets. This slide is just a few notes about IRAs and required minimum distributions. I don't profess to be a complete expert on this. I like to consult with financial advisors and accountants on a lot of these things when the details, the nitty-gritty details become necessary. But I thought I'd give you just some timelines and some ages just to be aware of, put in the back of your mind. Required minimum distributions are what you are obligated to take from your IRA. It's based on your age, and it's in the year after you turn 70 and a half years. There's a couple other provisions, like if you're not retired, then it can be a little different, but I won't get into those. Often you will see, even if somebody has a trust, that an IRA's first beneficiary designation will be directly to the spouse. And that's because the spouse has a special, I guess, rule that they can roll it over and become their own, and then the required minimum distributions will be based on the spouse's life. But that's the only one that can do that. So if you don't have a spouse, then the required minimum distributions are often based on your life, and if you don't meet certain timelines and deadlines, if your beneficiaries don't and you leave it to them, then it can end up having to be liquidated. This is an issue because the longer you leave something in an IRA, and the more it's going to grow tax deferred. A lot of times, the beneficiaries will just take a lump sum, and end up giving a lot of it away in taxes. Whereas if they would have done a stretch trust, or you would have designated the trust as your beneficiary, that had provisions about how you wanted that distributed, then that can stretch it out a lot longer. So that's just something to be aware of. You need to be aware of the dates September 30th and December 31st. September 30th is when certain beneficiary, I don't want to say designations, but you have to essentially report who the beneficiary is, and I won't get into those details, but just remember September 30th, and then December 31st of various years is typically when required minimum distributions, when that annual withdrawal has to happen. Do you have a question?
Well, is it possible to roll over an IRA without losing all of it to the bank fees?
That you'd have to ask your financial advisor.
Happened to us.
Yeah.
And we didn't know it was going to be that way.
Yeah, and that's why it's important whenever, if you are rolling it over or dealing with any sort of financial assets like that, that you really clarify that up front. But I mean, there's always fees involved, so. The next point goes in line with what we talked about last time, but keep a copy of your beneficiary designation forms. A lot of people rely on the life insurance company or whoever else to keep track of those, and I just wouldn't do that if I had a choice. So if you can, just keep a copy with your will or wherever you keep those documents. There are certain requirements for trust to be a beneficiary, so you just need to make sure your trust meets those requirements. For example, in our trust, we have about a page and a half of standard language that we include in all of our trusts that deal with it if the trust becomes a beneficiary of a retirement plan. And then to find more information, look at the IRS website. I provided I think there were frequently asked questions on the IRS's website about required minimum distributions. And I just thought it was pretty good little summary, quick hitter questions that might be helpful. And then your financial advisor and accountant can also help with those.
Can I make a couple comments about IRA?
Of course.
FYI, typically, now, I don't remember, it's been a while, 401ks and 403bs, but particularly IRAs, you can distribute to a beneficiary in one of two ways. A spouse can take it on as his or her own retirement investment. If it's a non-spouse, they have to do an RMD. Basically, you have to start paying 1 year after the year of death. You have two options. You can stretch it out over your lifetime, and those are based on the tax tables. We have three different types of tax tables in IRS code. Or you can take it out within 5 years and make a choice. And my experience, 6 or 7 years after the Roth IRA came into being, was that fiduciaries didn't know squat diddly about how to handle the distribution, and you need to be on the ball so that you, if you want to stretch it out, you know that you have that option. Otherwise, they typically kind of say, oh, you have to take it out within 5 years. And as you were saying, that is the poor way to do it.
Well, it just depends. For example, there are some people who that's their main asset. And if they pass away with a 14-year-old and a 7-year-old that need that money to live on, then they're just it's going to be better for those children to take that tax hit and move on. But for people who don't have to have that money, then it is good to know there are at least other options if they choose to elect those.
It could be a lot more valuable than
Yes.
it ever would have been in 5 years.
Yes.
It depends on the circumstance, but if you can stretch it, stretch it.
Okay, so now we're going to turn tables a little bit and just talk about generally, if I have a loved one that dies, where do I even begin? And these are just suggested steps. I'm sure any of you who have been involved in this situation probably have had little things come up that you would add to this list, so I don't purport this to be an all-inclusive list, but just some ideas. First, of course, you're going to have to deal with emotional shock, trauma, and whatever other issues you're dealing with. Make an appointment with a funeral director if that's what you choose. And if it is a funeral director, then ask for several copies of the death certificate. In every probate that I've had where there are beneficiary designations that weren't really done that well, or whatever the case may be, they all are asking for death certificates and often certified. So it is good to have those handy and ready to go. Then locate the safe deposit box if they have one, which we've talked about last time. Locate the family's important papers, their most recent will, and make sure it's the original. Trusts, life insurance policies, stock certificates, whatever other documents. If there's a promissory note that somebody owes them money, get all of that in line. Secure the assets. Don't start handing stuff out. If you're the executor or if you're not the executor, don't start handing stuff out until you've got all your ducks in a row. You need to account for all of those assets. If you have to go through the probate process, you're going to have to do an inventory and show exactly what the estate had when that person passed away. And then the trustee will also often need to do an accounting of whatever is in the trust at the time of death before they start making distributions. Forward their mail, cancel credit cards, subscriptions, make an appointment with your attorney and tax advisor to discuss implications such as probate, transfer on death designations, trust administration, taxes, guardians for minor children, etc., and see what is going to be needed for that estate. Just a couple notes, a final income tax return will likely need to be filed. For whatever reason, the IRS doesn't excuse payment of taxes when you die. So they're still going to require that. If a person dies with a prior year's return still outstanding and due, say they die on April 14th, you can get that extension to October 15th, maybe, but if they've already gotten an extension and they die on October 15th, you just got to be aware that that could be an issue because you have deadlines there. Yes.
I just made an appointment and just so I can be mentally prepared. And I needed a dozen death certificates.
Yes.
Just felt like I was passing out.
Yes.
Ended up with 3 or 4 left, but each of the children wanted one. I mean, you don't want to just keep cutting every order. It's nice just to have a pool.
Right. And same thing with, like, if you're appointed as executor, the letters that are signed by the court appointing you as executor, you'll probably feel like you're passing those out as well. So typically, like when we file probate, we'll get multiple copies of those files stamped so that those will be available. Continuing on, call the decedent's employee benefits office to start the process to pay any benefits. If the decedent was eligible for Medicare, Social Security, that kind of thing, you have to notify those government entities. Probably tell them the date of death and related details and figure out what benefits they're entitled to. And again, securing those assets whenever they come in and accounting for those, marking down when you've received them, how much you've received. Same thing with Veterans Administration if you have somebody that has served in the military. Collect life insurance, annuity, Social Security benefits. Again, keep track of all the money received and spent for tax purposes, reimbursement, trust accounting, and probate. For all these reasons, you might need to know what's gone in and out of the estate. Avoid contracting for anything while you are in an emotional state. For example, people that have businesses might get inquiries about buying the business within the first couple weeks of the business owner passing away. A lot of times it's good to take a step back and evaluate those options after some of the sting has worn off. I think it's never a good idea to enter into contract when you're in that emotional state. Update any estate plan for the survivors. So if your spouse dies or your daughter has passed away or your dear friend has passed away, it may affect your estate planning. So you may need to revisit that. And then make any changes to any ownership of assets. You may need to go present that death certificate to get the car that was transferred on death to you, those sorts of things. And then anything else that's particular to that decedent or that decedent's family situation. These are some website resources that I've come across that I thought had some just generally good, helpful, plain language information. The Kansas Board of Mortuary Arts, I've come across this in the past with my funeral home clients, and there's a lot of information on there about interacting with funeral homes and that sort of thing. I can't guarantee that everything they have on there is correct, but I think it's at least some good resources to start with. The Kansas Bar Association also has public information pamphlets, which include everything from why do I need a will, is a living trust for me, advanced directives, a lot of the stuff that we've talked about here, they have pamphlets for. And I have actually a couple hard copies of those if anybody would want them. I have them with me. And then Kansas Department on Aging has a lot of similar information, has information about Medicare and things like that. So those are all good resources to use if you just want some general reading information. And then there's a lot of other more specific techniques that that can apply to your situation. I just want to mention these so that you're aware of them. I won't go into all of the details because they could probably each be a whole other session on their own. But there's tax planning that you can do. For example, you might have heard of a credit shelter trust that you can include in your trust, and essentially that does what portability does. It protects your spouse's exemption and keeps everything in your spouse's estate instead of bringing it all into yours and then being taxed. And I won't go into all the details, but charitable gifting and trusts. A lot of times people have some charity that is, or church, whatever the case may be, that is dear to them, and there are certain assets that it's more beneficial to designate them as the beneficiary on than others. You can incorporate them into your trust. There's also irrevocable trust that you can do where you give a portion to the charity now, or you give the remainder to the charity, and it can help with estate taxes and income taxes, that sort of thing. Buy-sell agreements, I mentioned those earlier. Essentially that just says, there's a wide variety of them, but upon divorce, upon bankruptcy, upon disability, upon death of a business owner, on any of those circumstances, here's how those shares get valued, or those membership interests. Membership interests are associated with LLCs, which are limited liability companies. Shares or stocks are associated with corporations. That's how you hold ownership to a business very often. And these agreements will say how those get valued and who they get distributed to. Then there's long-term care, Medicaid planning that you can do, and I mentioned some of those earlier, and then special needs trusts, which we talked about a little bit earlier. And that is all I have, but if anybody has any questions or discussion points, I would love to hear them.
When you do an inventory for clothing, is there a minimum dollar amount, or do you list everything? I mean, do you go down how?
You mean like for personal property? It just kind of depends. You know, if the personal property is a specific antique that's worth something, then yes. But are you going to list every pair of pants and their underwear and their shirts? Probably not. It can be difficult. And sometimes you'll have to for tax purposes. Sometimes an estimate is good enough, but there has to be some like reasonable basis upon which you based it. If that's, you know, if you can find the same thing on eBay and what the going rate is, there's a lot of different ways you can.
It's not everything over $25.
Not that I'm aware of. We typically list everything, but for, like, I have one client that they just gave all of the grandmother's clothing to the nursing home, and so we just put, you know, given to the nursing home. It's probably really not worth anything in reality.
So there's a point at which it's not worthy of listing.
Yeah.
But I would think sometimes the sentimental value probably causes more rift.
That is exactly right.
Than actual dollars.
That is exactly right. When people leave all personal property just to be divided and don't specify who what goes to, or at least a method that their beneficiaries are to select. You know, if you have 3 beneficiaries, a friend, a child, and a child's friend or whatever, if those are your beneficiaries, then you can select a method by which you want them to choose, you know, round robin or whatever it is. But you're exactly right. If you give them $500,000 to split equally, you're less likely, probably, to have a problem or a dispute than you are if you leave them a grandfather's clock, a mother's ring, and something else. Anybody else? I did give an intake sheet, mostly because those are the types of questions, and I handed those out last time too, but those are the types of questions that you need to answer in figuring out a will, a trust, who you want to give to, what your assets are, that sort of thing. So I think last time we started on page 5 or 6 of that for the healthcare questions, and the rest of that deals with what we have talked about here today. So you can just use that for your own reference.
I have a trust that was set up by one attorney and they're no longer around, and you want to go to another attorney. Is there any particular procedure you have to do that? Because I understand trusts are kept at the state level. Do you file a trust at the state level?
No, it's a private document, so nobody else will have that. What will often happen with a trust is people want to amend the provisions, and so you don't necessarily have to redo the whole thing. You can, and this is different than a will, you can amend just that trust. So you could essentially execute a 2 to 3 to 5 page amendment to your trust and say, I want to amend these provisions, provision section number 3, section number 6, and section number 9. And sure. Sure, sure. And even if that attorney is around, if you just want to go to somebody else, that's, yep.
Is it a good idea to let the attorney keep the trust document?
No, I think you need to put it in your safe deposit box, the original at least. Now, the attorney will likely keep a copy, and that's what I mentioned earlier. Like, we won't keep the originals anymore because our malpractice insurer is getting a little bit upset about that. Anybody else? If nobody else has any questions, we wrapped it up a little sooner than 2 hours, but I figured people wouldn't mind that on a Thursday night. Thank you all for coming very much.